When the government is trying to compel Americans to speak or deliver a message, that's going to be really hard to justify under the First Amendment of the Constitution. One great Supreme Court case that illustrates this is Wooley versus Maynard. This is from 1977. It was written by Chief Justice Burger, very conservative guy. There was a dissent by Justice Rehnquist. And basically what it involved was the state of New Hampshire having a requirement that non-commercial vehicles, so basically the cars that you or I drive, bear license plates with a state motto. And their state's motto was live free or die. Another New Hampshire statute makes it a misdemeanor to, quote, knowingly obscure the figures or letters on any number plate. Letters, according to New Hampshire's Supreme Court, include the motto. So you cannot obstruct that motto on the back of your vehicle. So George Maynard and his wife Maxine are Jehovah's Witnesses, and they find that the motto is offensive to their moral, religious, and political beliefs. So they had their cars, and in 1974, they were charged. They filed 1983 claims, so basically saying their constitutional rights were violated. They sought injunctive and declaratory relief against the enforcement of the statute. So they're saying, hey, court, please find this unconstitutional and prevent them from doing it. So does the law get to survive? Does the law get to be enforced? The answer ends up being no, as I kind of hinted earlier in the video. So this gets to the U.S. Supreme Court. Chief Justice Burger writes, states can't do this under the First Amendment. The right to speak includes speaking itself or refraining from speaking. So yeah, don't compel people to speak. People have the right to refrain from speaking. He talks about West Virginia versus Board of Education versus Barnett, And that case, of course, involved the Pledge of Allegiance and how the Board of Education could not make its students recite the Pledge of Allegiance. That was compelled speech in the eyes of the majority, and that case is still good law. So he says Barnett is like this case in that we've got a state measure which forces an individual as part of his daily life to be an instrument for fostering public adherence to an ideological point of view he finds unacceptable. New Hampshire statute, of course, is forcing him to use his private property as a mobile billboard, Burger says. And he actually says that this case is not quite as egregious as Barnett. In Barnett, he thought that what they were forcing the students to do was more serious, but the outcome of the case ends up being the same, of course. So public adherence to an ideological point of view he finds unacceptable. They cannot make him do that. And cars are virtual necessities for most Americans. So that's important. They're basically, you live in New Hampshire, you're probably going to have a car, you're going to have a license plate, and they're making the license plates all have this message, and you cannot do anything to cover up that message. So the state does have an argument for interests that it thinks justify this. It advances the interests of facilitating identification of passenger vehicles and promoting appreciation of history, individualism, and state pride. But Burger has a response to that. These interests are not legit. They're not going to win because New Hampshire license plates normally have a specific configuration of letters and numbers, which makes them distinguishable without that motto, live free or die, being on them. And also, promoting history, individualism, and state pride is an ideological thing. So it's content-based. They can't do that. The state cannot do that. The state cannot enforce ideology. So this live free or die thing on the license plates, it's a no-go because of that. The dissent, written by Justice Rehnquist, joined by Justice Blackmun, says New Hampshire didn't force Maynard to say anything. There was no communication of ideas. It's just a license plate, bro. That's basically his argument. So it's nonverbal actions. Nonverbal actions are not speech. The action is just put this license plate on and refrain from covering it up. Having the license plate is not affirming or rejecting that motto. So yeah, the motto, you can disavow it, kind of like what Justice Frankfurter said in Barnett, they can disavow the Pledge of Allegiance. Rehnquist is saying, you can disavow the motto. You don't have to like it. We're not saying you have to agree with it. We're just saying that you have to have it on the back of your car. So people in New Hampshire can still voice disagreement, he says. This is way different from Barnett and warrants a different result because, yeah, it's a lot more benign than Barnett. He compares it to In God We Trust on currency. We all carry currency. All of us have money, probably at least to some extent, a coin or something. And he says that doesn't impinge on the First Amendment rights of atheists. It's an interesting point, actually. But yeah, his view did not win the day. People in New Hampshire did not have to carry that motto on their license plates, and it was a big win for free speech. I hope this video is helpful to you if you're someone who is studying First Amendment law, if you're in law school, undergrad, high school, reading about First Amendment case law, and you need someone to summarize it up really quick for you. I am so happy to be here for you. I love talking about the First Amendment. I love talking about law. Let me know what you think about this case in the comments below. Please like, comment, or subscribe to the channel. Thank you so much for watching, and I look forward to speaking to you in my next video.